So welcome everybody to our webinar today on a practical guide to importing for both new and very experienced importers. My name is Sam Hunter and I'm the Events Officer for Semlet's Growth Hub. And this is the third in the series of 11 EU exit webinars that we're running in partnership with Oxlep, BBF, Cambridge and Peterborough Combined Authority and New Anglia Growth Hub. And it's all aimed at helping businesses for international trading post-EU transition period. So I'm going to introduce Andrea now, Andrea Collins of the Export Department. Andrea is an international trade specialist with over 24 years in the industry, and she specialises in importing, exporting, EU exit, business resilience and business growth. She's an ambassador of the UK micro businesses and SMEs, and she launched the export department to assist these businesses expand their horizons internationally and raise the profile of UK goods and services abroad. So today, Andrea is going to provide you with an overview of the exporting process in practice and highlight the way the EU exit will impact trade operations and compliance. So just a quick bit of housekeeping before I hand over to Andrea. If you have any questions throughout, then please use the chat box. You've probably seen there's a few things in there already, so that should be highlighted to you. Please use that, and Andrea will do her best to answer during the session if she can, or if not, we'll come to any outstanding questions at the end. So I hope that's okay, and over to you, Andrea.
Wonderful, thanks ever so much, Sam. Let me just share my screen. So okay, hopefully everybody can see that. So yes, hello to some newcomers. Perhaps some of you have attended the previous two that we've done. But yes, as Sam says, today we're going to be talking about exporting and predominantly what we need to be doing now to prepare for that kind of seamless continued trade beyond the end of this year. So we'll talk a little bit about now and what our trading landscape looks like beyond the 31st of December, which has implications around origin, which we'll touch on shortly. We'll talk about Brexit and its impact, and then most importantly, we'll move on to those key considerations and those practical steps that you need to make now in order to continue exporting without disruption come the 1st of January. And as usual with all of our presentations, we've got a ton of signposting and sources of additional information and support at the back of the presentation. So you'll receive copies of the slides, and I believe the presentation may even be recorded. So it's important that you've got that information to go away with and can refer back to. So if we look at now and beyond the 31st of December, I don't want to labour this point too much because we have left the EU, but I think it's important to recognise the kind of rights and protections that we had as part of the EU. The UK was very much at the forefront of creating these directives that protect us as consumers and as nations. And I think really the point that I want to get across is not to lament the fact that we've left, although personally I do. It's more to kind of explain why the process, the withdrawal process and the process of the transition is just so complicated, because we have been so almost inextricably linked to the EU over the last 40+ years, and we could never have removed ourselves from that body seamlessly and within the time that we've been allowed. So the very fact that we're not where we need to be with regulation, that we're not where we need to be in terms of negotiations, really should come as no surprise when you think about how closely linked we have been with those other 27 member states over the last 40 years. The current position, so we're in the transition period. We left the EU on the 31st of January. But we've been in this transition period, we've been in this kind of like bubble whereby, to all intents purposes, nothing has really changed for us. We're almost oblivious to the fact that we're no longer represented in those EU institutions, agencies and bodies. You know, we've continued to enjoy the single market and the customs union. We've continued to trade using that global landscape of FTAs and other bilateral trade agreements that the EU has negotiated over the years. And so to all intents and purposes, nothing's changed. Our goods still flow between the UK and the EU. There's no customs declarations, there's no border controls or checks. You know, it's been free circulation of goods and everything has moved very freely and very, very easily. On the 31st of December, the transition period ends, and there really is no legal mechanism for extending the transition period now. I was on a webinar with a very senior person from FSB this morning who kind of, you know, understands the whole legalities of the transition period, and he confirmed this morning that really there is no mechanism for extending it. So we are down to the wire here. We do have less than 6 weeks to prepare. And I think it's important to recognise that some things are coming into place irrespective of whether or not there is a trade agreement struck within the next 6 days or whatever the new kind of, you know, expectation is. So regardless of whether there's a trade deal arranged, we do become a third country in the eyes of the EU. So all of those third country rules apply. We decided when we left the EU that we didn't want to negotiate access to the single market or the customs union. So therefore the EU customs union that we've been part of is replaced by the new UK customs union, which has some implications around Great Britain and Northern Ireland, because although Northern Ireland will remain part of the UK customs union, it also remains closely aligned to the EU in terms of regulation and VAT purposes and so on. So this whole model that's set out from the Northern Ireland Protocol poses significant issues for GB traders moving their goods into Northern Ireland. Not so much from Northern Ireland to GB, because we'll cover that off later. That's still covered in unfettered access, as the government calls it. But there are issues around the Northern Ireland Protocol for you know, GB companies moving their goods. So going back to it, we have our new UK customs union. We can no longer use those free trade agreements that have been negotiated, some 70 plus, and then a whole load others been ratified currently. And then our customs controls come into place. So if you've joined any of the previous sessions, you'll know I talk about the new border operating model that lays out formalities at UK borders for goods coming into the UK, and also goods being cleared at UK borders to go into the EU. So we need to get our heads around those customs controls quite quickly, and around those customs declarations that become mandatory for our exports moving forward. So I often show this slide just because we're going to be talking about origin later on. So, you know, in addition to our free circulation of goods within the EU, we've also been able to export our goods to other markets, and our customers in those destination markets have been able to import our goods at a reduced rate or a zero rate of duty. That's what we call preferential trade. And in many respects, our ability to do that is severely hampered moving forward when we lose access to this global landscape, if you like. So what does it look like currently? Well, I think it's fair to say that the UK government was a bit, they had their hands behind their backs, really. They were stuck as to what they could do with regard to negotiating new trade agreements. You know, the UK set out very clearly it wanted to be master of its own destiny in terms of global trade. But actually it wasn't really able to start negotiating with nations until the transition period started. So where we're up to at the moment is we have a number of what we refer to as continuity or rolled over agreements with some 22 nations, which is great. It's a good start. And obviously the new UK-Japan free trade agreement was phenomenal news, especially for certain sectors like our automotive sector, where, you know, being able to remove those tariffs and those kind of barriers is really important for that just-in-time manufacturing. But it doesn't change the fact that, you know, these 22 agreements only represent some 10% of our global trade. So it does pose export pricing issues, if you like, when countries that we're exporting to now have to pay those duty on our goods, which makes it difficult for us to compete with local manufacturers in that market and against other international manufacturers that may have preference agreements with that country. So it is a challenge. It's out of our control. So I don't want to labour it too much. It's just important to recognise that our export pricing and our competitiveness globally, not just in the EU, is hampered through our decision to leave the EU. So what does Brexit actually mean? What are the additional formalities and considerations? Well, we know that there are going to be documentation requirements. So for goods moving into the EU, you know, we're going to have to now make our export declarations. We're going to have certain documentation to clear those goods, not only at UK borders, but also within the EU. So we get more into the realms of certification and licensing, perhaps pre-authorization to ship certain goods. So that means in the UK on certain systems, and for our the importers, so our customers, to register on local systems that they have there. Goods moving into the EU will be subject to far more scrutiny. So we need to make sure that not only is our export declaration correct, but the documentation that needs to accompany it is really up to scratch. Otherwise, you know, worst case scenario, goods can be confiscated. More irritatingly, goods can be held up, which relate to costs, and then also quite an unhappy customer at the other end when they're waiting for their goods and they can't clear customs. So the accuracy of the declarations and making sure that you have all of the documentation required to accompany the goods is paramount. Product origin I've talked about as well, and we'll go on. We've got a specific slide on that, but our ability to trade under preference is hampered, and, you know, moving forward, our goods won't be of EU origin, whereby we can count EU raw materials and processing into the accumulation for our origin. It poses big problems for manufacturers who now have to start looking at their bills of material to determine whether they've done sufficient transformation to those non-originating goods in order to be able to say it's of UK origin. And I think the implications there are, if there is a UK-EU trade agreement negotiated, in order for exporters here to be able to take advantage of that and have their goods go into the EU at a preferential rate of duty for their customers, they're going to have to be able to say that their goods are of UK origin in order to comply with the origin protocols within the agreement as it you know, transpires, really. Our export pricing, obviously that's impacted by the imposing of duties and import VAT going into the EU. But I think when we talk about competitiveness, we're not just talking about the fact that our goods might be more expensive. It's also the fact that our goods are going to be more difficult to obtain. And no free trade agreement is going to remove those barriers in terms of those customs declarations and documentation and so on. So it's kind of like a double whammy in terms of our competitiveness. And I think UK businesses are going to have to really step up to the plate and think about ways that they can overcome those. So we are renowned globally for being quality. We provide quality goods and we provide quality services, and we're going to have to think of other ways to differentiate ourselves in order to keep competitive in those markets and overcome those tariff and non-tariff barriers that are imposed through Brexit. There's licensing controls that we need to think about as well. So come on to that later, but in the past, you know, dual use goods, for example, haven't required licenses going from the UK to the EU. That will change. So that puts a burden on you, the exporter. And then we're looking at potential customs delays as well. So, anybody that joined the session last week, I talked about how HMRC has put a number of measures in place to try and deal with the volume of customs declarations and formalities, and they've seconded a number of ports, airports and rail terminals to do this. But there's still going to be delays, and it's questionable whether the southern ports, even with that extra capacity, will be more overwhelmed than the northern ports. So I think it's really important that you understand the route of your goods, how your goods are going into the EU, and that you start having those conversations with your buyers or your customers now. Talk about forward ordering, talk about ways that you can mitigate any potential delays and therefore disruption to your trade and theirs. So considerations and practical steps. So we're going to talk a little bit about the new border operating model. We covered it extensively last week, but we'll touch on it just from an exporter's perspective in a moment. We'll touch a little bit on the Northern Ireland Protocol and the implications of that. EORI numbers I am going to stress again, but from the perspective of EU EORI numbers, which may be required depending on the Incoterms that you use with your customers. We'll take a little look at the export documentation, but we have a dedicated webinar coming up with that in a couple of weeks. I think I'm losing track of where I am, but there is a dedicated documentation, international documentation webinar coming up. Talk a little bit about commodity codes, can't stress that enough. They are really, really important and play a huge part in us being able to clear our goods at UK borders and our customers, importantly, being able to clear them in the local market. We'll touch a bit on export pricing and how we can start to notify customers of what those uplifts are going to be, or if you're going to absorb those costs, what those liabilities are and how they impact your margins and so on. So we've got clarification not only around the import duties that we will pay on goods coming in from the EU, but we've also got clarification on import duty that our customers will pay on our goods going into them. We'll touch a little bit about export licenses, a little bit about compliance regulatory wise, because that is still, in many respects, there are still sticking points in the negotiations. And we've been asked for months now, years actually, what we think will be the biggest impact on UK businesses. And we've almost poo-pooed the tariff side of things. It is important and it does impact our export pricing and our margins here in the UK, but it's really those non-tariff barriers that are going to be really painful for companies, especially in this kind of teething process that we begin at the beginning part of next year. Touch a little bit about intellectual property rights, and then I'll finish off with client supplier contracts. Okay. So the new border operating model, we touched on it last week. It lays out border controls essentially for goods coming into the UK, irrespective of where they're coming from, the UK, the EU, or the rest of the world. I think as an exporter's perspective, we're disappointed that the government hasn't perhaps introduced a phasing in method for declarations as they have done with imports. So importers are able to delay their declarations or defer their declarations for the first 6 months. And I think that's been done primarily because import is classed as being more complicated, but that doesn't help you from an exporter's perspective when you're thinking, well, how am I going to grapple with this new way of working? So I think there's a couple of things to mention, from an exporter's perspective with the new border controls. Safety and security declarations are going to be required from the 1st of January because that's an EU. The EU are mandating this, whereas the UK aren't mandating those until July for the importer side of things. There are goods with additional requirements, so those kind of controlled goods or goods that require certain certification or licenses. If you are exporting any of those, then there's going to be additional obligations placed on you around those kind of pre-notifications, pre-authorizations and documentation, if you like. And obviously our goods will be subject to a lot more checks going into the EU. So not just documentary checks, physical checks, identity checks. So again, going back to having that documentation in tip-top condition and making sure that, the goods are packaged correctly and, your packing lists and everything are how they should be is going to be really, really crucial. Importantly, the border operating model doesn't cover the flow of UK GB goods. For that, you have to refer to a separate publication. anybody impacted, and I can't recall, I think we might have touched on it last week, you should really sign up to the Trader Support Service, which is a dedicated package of support around goods, around companies that are impacted by the Northern Ireland Protocol, if you like, and how we continue to maintain that kind of fettered access, unfettered access, not fettered access. So moving on to the Northern Ireland Protocol, so how it works effectively is, a big part of it when it was discussed in the withdrawal agreement was making sure that there was no hard border on the border of Ireland, which there isn't, but the outcome of that is that there is a legal border down the Irish Sea. So even though Northern Ireland remains in the UK Customs Union, there are going to be some documentation that needs to flow between GB and Northern Ireland as a result of the Northern Ireland Protocol. So how it works is goods coming into GB from Northern Ireland should have that unfettered access, so they should be able to move without documentation, without checks, without any kind of declarations and so on. However, going the other way, it becomes a little bit more complicated, and this is where GB companies may need that extra help. So goods going into Northern Ireland may need declarations. They may be subject to duty if those goods are destined for Ireland, so if they're kind of transiting through Northern Ireland, or similarly if they're at risk of going into Northern Ireland as well. So my advice at this point is to sign up to the Trader Support Service and to have a really good detailed chat with your freight forwarder, whoever is responsible for moving your goods into Northern Ireland currently, to understand how prepared they are, and they should be able to feed back to you in terms of any additional documentation that you need to provide with your goods. But it is just another layer of complexity that we really could have done without. So on to EU EORI numbers. I'm hoping as exporters, you've already got them, even if you've just been trading within the EU. HMRC blanket bombed everybody when we were looking over the cliffs on no deal Brexit last year. So you should have yours. If you don't, there's a link at the back of the pack to apply. It takes about 5 minutes to fill in the form and 10 days or so to actually get it turned around. How you identify it is, it's typically, if you're VAT registered, it will be a number that starts with GB, and then it'll kind of like be your VAT number. But that's your UK EORI number, and that's what identifies you to HMRC as an economic operator or a trader, if you like. Now, why I want to touch on EU EORI numbers is because we're providing a lot of one-to-one support with clients at the moment, and some of our clients are delivering into the EU under what will be deliver duty paid. So historically, intra-EU trade has gone door to door. So either the customer collects from the UK premises, or the UK supplier actually delivers door to door with the customer. In order for that to continue, and where companies do want to continue delivering door to door, then they effectively become the importer of record in the EU. So they become liable for import duty, import VAT, and then getting the goods and navigating any kind of customs formalities that come with that. In order to do that, they require an EU EORI number as well as their UK EORI number. Where you're not so precious about continuing to deliver door to door, if you can switch the terms to delivered at place or delivered at place unloaded, so DAP or DPU, then that's far more preferable. Customs authorities are massively complicated, and it's hard enough navigating our own, being HMRC, without having to navigate lots of local authority, lots of local offices in the EU. So I think DDP is one to be avoided if possible, because it does have that EU EORI number requirement. It also requires a local registration for VAT, because you'll be accounting for import VAT. And some 19 out of the 27 member states are insisting that UK companies registering locally for VAT appoint a fiscal representative, which is that company that basically liaises with the VAT office, but there's a cost associated with that and guarantees and so on, because that company technically is partially liable for your VAT liability. So it's a complicated area if you still want to continue delivering deliver duty paid. On the flip side of that, where you might be making your goods available to your customers to collect, so you're basically having them arrange the carriage and so on. Ex-works is a term that we really hoped had disappeared out of Incoterms 2020, but no, it's still there. It has a number of vulnerabilities around the loading of goods at the exporter's premises anyway. But in addition to that, there's also a requirement on the importer who's collecting your goods to make the export declaration here in the UK, which, similar to DDP, do they really want to be navigating HMRC in order to do that? And in order to interface with HMRC, they will need a UK EORI number in much the same way as you'll need an EU EORI number. So where possible, do your customers a favour, look to negotiate and switch to something like free carrier. So you're responsible for making the export declaration, and they don't have that requirement for that EU EORI number, and also just navigating a foreign customs authority, really. So that's EU EORI numbers. Export documentation. This is the wonderful document that we refer to as the SAD. I like calling it SAD. It's a single administrative document. Those of you who have only ever exclusively traded within the EU will probably not have seen this, or might have seen it on recent webinars. But this is the document that is used for both imports and exports. So import declarations have less fields that are filled in, and import declarations have more because they get involved in the duties and taxes and so on. In reality, you wouldn't see it in its paper copy. You'd be using software to the interfaces with Chief, which is HMRC's underlying platform, or you'd be using a freight forwarder to fill this in. But this is the document that contains all of the information, and I think it's kind of, it contains information that you've probably never had to think about before exporting your goods. You know, we talk about customs procedure codes. You've not really had to think about that now, but because our dispatches to Europe become exports to Europe, we now need to make clear to customs authorities here and in the local market that it's a permanent export, so there needs to be a code associated with that. Obviously, commodity codes are really important as part of this, because they dictate the duties and taxes that your customers will pay in the local market. So you've got this kind of overriding customs declaration, but then you've got a whole load of documentation that that supports that as well. So depending on your commodity code, then you will be asked to provide a number of other documents to support that shipment, and that could be, as we said, certification, certificate of origin, licenses, or whatever. Chief, being HMRC's core system, acts as a kind of has a security role to play as well. So where a commodity code is input into the system, it will instantly flag if there's any special documentation that needs to accompany controlled goods, for example. And then I think, like we said, you know, those physical identity or documentary examinations are really important. So the entry that's made into Chief, or into the software that interfaces with Chief, the accuracy of that is really important. Not a lot of people realise that actually when you're using a freight forwarder to make your declarations, you can actually check on what they're inputting on your behalf. So you can obtain MSS data from HMRC that allows you to check that, you know, those standard areas of that can be problematic, from transposing certain digits or leaving a digit off, like EORI numbers, commodity codes, CPC codes. You can check on the declarations that they're making, so you can make sure that they're representing you correctly, because ultimately you, as the exporter of record, are 100% liable for the accuracy of that declaration, unless the freight forwarder is acting in an indirect capacity for you, which is very rare. They usually act exclusively on your instructions and bear minimal to no liability unless they've made a mistake and not carried out your instructions correctly. Compliance is another one. It's really important. With export, we zero rate our invoices for VAT purposes. And if you are audited by HMRC, they want you to provide proof of export to show that your goods physically left the UK. So, you know, they could be zero rated for VAT. If you can't provide that proof, then you become liable for that VAT, which is obviously not what you want. So I think the threshold is 90 days from the declaration being made. Those goods need to have been shipped, and you need to be able to maintain that proof of export and make it available to HMRC for 6 years from that declaration being made. So your I suppose getting to grips with your export dossiers and kind of making sure that your export files and your documentation structure is correct is really important moving forward. Proof of export is something that HMRC will always jump on because they know it's an area where our exporters are not always that compliant. We touched on this briefly last week. I love this graphic because it kind of shows the complexity of all the different systems that go into managing our imports and exports. Don't want to labour on it too much, but it is in the border operating model. And it just shows kind of like the different systems that are notified when a certain shipment is declared, if you like. So there are triggers for certain databases to be notified. There are triggers for certain documentation to be provided. If you haven't pre-registered, then that's going to flag. So it's really important looking at the border operating model that you familiarise yourself with what your commodity code requires and the systems that you need to interface or get registered on now rather than later, because they'll be required from the 1st of January. Commodity codes, this is my passion. Really, really important that they're right. Trade with the EU in the past, you know, goods have moved, they've not been checked. We might have been working with a commodity code that, you know, isn't actually accurate. It becomes absolutely paramount from the 1st of January that these codes are correct. So you should be ideally checking all of them, or at least sample checking you know, a significant proportion of them to make sure that they are right. Where you are unsure, you can refer to HMRC for a non-legally binding advice, if you like. So you use their tariff classification service. Don't ask them for a commodity code, they won't do that. You have to go to them with your commodity code that you think is right, and then give them as much information about your goods as you possibly can. They'll then come back to you typically within 5 days and say, you know, based on your description of your goods, I think the commodity code is right, or alternatively, actually, we think the commodity code should be this. Now, I think that's great in many respects because it's a piece of paper that you can print off, you can put in with your records. If you're audited, you have something to refer to. But HMRC go to great lengths to explain to you that it's not a legally binding decision. Where you want that additional security, then you have to apply for a binding tariff information, or BTI. And again, all these details are at the back of this presentation. But that's a legally binding decision from HMRC that says that they've almost assigned you this commodity code. So it gives you that peace of mind, and that's legally binding for 3 years. What else about commodity codes, really? I think it's taking those steps. It's just sanity checking what you've got in place already, consulting the tariff, making sure that, because the other thing to mention that a lot of importers and exporters aren't aware of is that the tariff is an organic tool. So it's being updated all the time. There are new commodity codes being released. So you might have your goods historically classified under other, but subsequent to that, you know, they could have released a commodity code that's nearer your goods. So subscribing to the updates is really important as well. And again, I've given the link at the back of this presentation. Look into simplified procedures. There are less simplified procedures for exporters than there are for importers, unfortunately, but there's some of them that are worthwhile thinking about. So, you know, if I was to pick out one at the moment, is the simplified export declaration. So, as I said, with the new border operating model, they're phasing in making import declarations, but the export declarations are mandatory from the beginning of the year. But as an exporter, you can obtain an authorization to do simplified declarations, which means you could essentially make a declaration in your own commercial records and not have to make a supplementary declaration to HMRC until 14 days from that point. So it's questionable whether or not it helps, or whether or not you just want to get your head around the whole thing and start doing it from scratch, but it is there as a simplification. Other ones I'd mentioned, so where you're exclusively exporting and you don't want to use a freight forwarder, there is the national exporter system whereby you can make your own declarations, because export declarations are, you know, typically easier. But on the flip side of that, I do think that, you know, customs intermediaries at the moment are really worth their weight in gold. So it might be something that you want to move to, but I certainly think that from the 1st of January, if you have the option, of extending the service that an existing freight forwarder already offers you and have them cover the EU, or perhaps you might want to gain recommendations and have somebody come in to manage that tranche. I just think you've already got so much to deal with in terms of getting your head around duties, taxes, VAT, regulation, that having somebody take away the pain of the shipment might just, be a good idea for the short term. Export pricing. So we do have clarification around the kind of import duties and VAT that our customers are going to be paying on our goods when they go into the EU. And we consult really two different databases here. So we've got the EU Market Access Database, which has been in operation for a long time now. And we can scroll down to EU tariffs and search as a third country. We can't search as the UK right now or GB because we're still in the EU. But if you set your country criteria as China, for example, because there's no bilateral trade agreement between China and the EU, and then put in your commodity code, that will come up with the third country duty, because as I say, we're going to be a third country. So it will come up with, in the event that there's no trade deal between the UK and the EU, then it will come up with a duty that will be applicable to your goods going into the EU, because from a third country, which is what we'll be. The other database is the Where Would You Like to Export To, or the Check Duties and Tariffs. I really like this one in so much as it's providing details of the documentary evidence that you're going to need to supply with your goods. So in order to get your goods into a certain EU country, you can select the country, say France, which is obviously France in brackets EU. But then for your commodity code, it will come up with all of the documentation that you need and any kind of pre-registration that you need for those goods in order to clear them from the 1st of January. So using those two systems in parallel is certainly helping the clients that we're working with. Country of origin, I wanted to pick up on just from the perspective that, as I mentioned in the beginning, those EU raw materials and that processing that might be done in another EU member state, we can't apply those, or at least in the absence of a trade deal, we can't apply those to our own locally sourced goods and processing done in the UK in order to come up with that kind of accumulation of EU origin. So because we're a third country or the EU is a third country to us, their goods or goods that originate from there, any processing that's done there, it becomes non-originating. So there is a real task, and I get afraid that a number of manufacturers are not either aware of this or are not doing it currently. They need to start examining their bill of materials to understand what components originate in the EU and what components come from the UK, and whether or not the amount of processing or manufacturing that they're done here in the UK is enough to transform the goods, if you like. So when we talk about origin, we talk about goods that are either wholly obtained in a country, and I think I mentioned last week or the week before, that would be kind of cattle that are born and raised in the UK would be of UK origin. Crops that are harvested in the UK would be of UK origin. But obviously our international supply chains are so complicated now. We bring in components from all across the world. So that bill of materials is really important, and it changes frequently as we source alternative suppliers. So origin of components should be passed through the supply chain. So when you're bringing in goods that you then use to manufacture your end product, you should have the origin of those goods. And it's a case of doing that calculation to determine whether the goods, your finished goods, can be classified as UK origin. And of course, that becomes really important in the event that there is a trade deal between the UK and the EU. Because in order for your customers, as I said earlier, to be able to claim preference or import your goods at 0 or reduced rate of duty, you're very likely going to have to meet the origin protocols in that EU-UK trade agreement. And so your product will need to be of UK origin and will need to kind of, there's kind of a calculation that says that your non-originating material can't exceed 40 or 50% or so. And we don't know what those origin protocols are going to be in the negotiation yet, but understanding the makeup of your goods now is really, really fundamental to being able to qualify for that preference when a trade agreement's there. Export licenses, really good to get our heads around this. We often think about export licenses as being just for military goods or dual use goods. but actually there's other requirements for export licenses, like the movement of fine art and so on. So against your commodity code and the tariff, it will dictate whether or not you need a license. And essentially without it, you're illegally shipping. So, you know, if your goods did by any miracle get through without the license, which they really shouldn't, then you're not acting legally, if you like. It is your responsibility as the exporter of record to provide any license or certification that needs to go with your goods. And as I mentioned earlier, dual use goods is probably an area, if you are trading in those goods, that can be used for both military and civil purposes. So, you know, that can be goods, it can be software designs, it can be all sorts of stuff. But if it's classified as dual use, in the past we've been able to take those goods into the EU without a license. That changes from 1st of January. So our dual use goods moving into the EU will require an export license. Motoring through here, regulatory compliance, we've touched on it in previous sessions. I suppose the biggest one for me and some of the clients that we're dealing with is the REACH registrations, where you know, companies that are dealing in chemicals and want to continue supplying to the EU market now have to have their registration managed by an EU body, for example. So the fact that they're registered on the UK REACH system isn't going to be sufficient for them to move their goods into the EU. So that's a bit of an issue there. GDPR is another big one. We're still at that sticking point in the negotiations where the UK is still not quite meeting the adequacy levels that the EU is exploring, shall we say, at the moment. Even though we will incorporate GDPR into UK law, there's these adequacy levels which are still a stumbling block in the negotiations. So the only thing we can do as exporters, if we are in that category whereby we either obtain, process, store data from EU customers, we need to be able to put, have to put contracts into, clauses into our commercial contracts to cover ourselves. Similarly with e-commerce providers, you're going to have terms on your website or in your customers' terms and conditions until we kind of get the lay of the land with GDPR. But to cover yourself from a legal standpoint, you really need to get on top of those clauses sooner rather than later. And I've included the link to the Information Commissioner's Office at the back of the pack, so that should help with that. Intellectual property, couple of things to mention here. So any trademarks or designs that are registered in the EU won't be recognised in the UK from the 1st of January. However, the UK is kind of replicating those. But what it means from an administration perspective is you're now going to have two sets of trademarks to kind of, or designs to manage, whereas before you would have just had one. Other things that clients are coming across is EU domains as well. So anybody that has a .eu domain, the ability to use those will be switched off. I think it's February time. So you have the option of either transferring your website over to a UK domain, which many clients don't want to do because, you know, they've got brand recognition with the .eu domain, or you have to have an EU body be the registered keeper of that .eu domain. So there's considerations there as well. And then supplier and client contracts. So here, as always, scrutinise your contracts. Are there any terms in there that relate to us being a member state of the EU, if you like, because we're not going to be. So could they raise legal questions later on, or perhaps legal issues later on? So those contracts need to be scrutinised. And from an Incoterm perspective, so you remember me talking about DDP and experts earlier on, start having those, if you haven't started already, start having those dialogues with your customers to remove the ambiguity around delivery obligations. So that's what Incoterms do, really. They remove the ambiguity, they provide clarity around who covers the costs, who covers the insurance, and who's liable for anything that goes wrong. So getting to grips with what Incoterms are, if you don't know already, the Incoterms 2020 book is out now. It's great bedtime reading, just like the new border operating model. But it's quite easy to digest. But then there's also the local chambers, do training around Incoterms, as does the Institute of Export. So you might want to familiarise yourself with what the Incoterms are and what, you know, your obligations and your buyer's obligations are for each. But it's really important that you start putting those in your contracts and making it explicit that your responsibility starts and stops at a certain point and your buyer takes over from that point. And as I say, if you can avoid those two extremes, so DDP or Ex Works, they're two extremes of the Incoterm spectrum, and they both bring issues, especially with Brexit. And then, as per usual, I'm just checking the time because I know that there's another presentation coming after this. Sources of information. So I've put a lot down here. Everything that I've talked about today is on here in terms of following up to this and further, clarification around things. You can obviously contact us directly. My contact details are on the next slide, and please do so if you've got any issues, or you can go through SAM or contact your local growth hubs. But there's lots and lots of information and support out there. It's just a question of knowing where to go to get it. And I hope that I've kind of provided a bit of a framework for that and some signposting for how you can go and read up on stuff that you need to read up on. And I think that's really it for me now, Sam. If do you like me to go and have a look if there's any particular questions?
Yeah, thank you, Andrea. We have got quite a few questions in the chat and also the Q&A box. Can you see both of those, or do you need me to?
I can see. Yes, I can go. I'm in the Q&A at the minute. I'll look at Q&A and then I'll go into the chat.
Let's do those first. Excellent.
Yeah, so Michelle's asking, we have a product, crackers, that's made in Greece. We don't currently state where the product is made on the label. We would like to know if we're now required to do so. Labeling is down to, there's a couple of things there really. So labeling is down to certain products. So certain products will require that you put the origin of the goods on there. So, cosmetics and so on require that the product shows, which origin it is. And I don't really know about crackers without looking at the commodity code. In terms of stating the origin, obviously, if it's made exclusively in Greece, then it's of EU origin. So that allows you to obviously trade in preference with those countries outside of the EU where there's a free trade agreement. So it really depends on, if you look at the commodity code, you'll see all of the EU regulation that hangs off that commodity code for that product. And it might well be that as part of that, you need to state the origin of the goods on the labeling. I'm just not quite sure without knowing what the commodity code is and having looked at it. But look at the commodity code and see all of the documentation that hangs from that, and that will give you any regulatory requirements attached to that. So Irene, I only export goods to the EU or outside the EU using international couriers. Yeah. Will I need to make new declarations for exports to the EU that are different to those needed for current exports to outside the EU if I continue to use the same couriers? So if you're using what we call those fast parcel operators or FPOs like FedEx and DPD, they're pretty well set up for Brexit, actually, from what I can gather. So they're trying to make the process as seamless as possible for UK companies. I suppose the thing I would ask there is what the nature of the goods are, and this is an important point. So if those goods are going to consumers in the EU, then there is a bit of a problem around VAT for e-commerce sellers at the moment, which I'm thinking if you're sending DPD or FedEx, then maybe they are B2C. If they are B2C, then there is an issue around VAT, as I say. So in the past, e-commerce sellers have been able to sell a certain amount of goods into the EU markets without having to register for local VAT. We've had what we call the distance selling threshold. So in some markets, like in Germany, you've been able to sell in as much as 100,000 euros worth of goods into Germany without registering for VAT in Germany. Those distance selling thresholds are removed from the 1st of January. So there's a real issue for e-commerce sellers until the EU's one-stop shop comes into place at the 1st of January. And I'm quite happy to forward information to anybody that this actually impacts, where they can, you know, go and find more information about it. But there is that kind of 6-month space where we're thinking, what do our e-commerce sellers do here in the UK? You know, what are they actually, how can they deal with VAT in that local market without that distance selling threshold? And really, I'm not a VAT specialist. I've had to get my head around it quite quickly, as you can imagine, over the last few months. But where you're unsure, consult with a VAT specialist, such as Simply VAT is a good one. Avask is also a good one. But they'll probably say the same, that there's that 6-month gap for B2C goods where, you know, we're really saying the only alternative that companies have is either to have their consumers pick up the import duty and VAT to clear their goods at customs, which obviously is not good from a customer experience perspective, or they must register for VAT in those local markets, which obviously is just for a small company just a huge headache. What the one-stop shop system will do is allow a UK company to register in just one EU market as a non-union taxpayer, and then they can take advantage of those distance selling thresholds again. So they'll be able to just file one-stop shop return for all of the goods that they supplied across the EU within that time. So that's a complete separate level of complexity, but if it does impact anybody, I'm quite happy to point them in the right direction. If goods go FedEx, B2B, will it be sorted out via FedEx, or do we need to do customs declarations? FedEx will guide you on there. It might not be the C88 that I showed you earlier on, but FedEx will have a system or an interface that allows you to make the customs declaration. So it might prompt you for more information than you've had to give previously, but that system should be in place. I can just see that, sorry, Irene has said, my company claims selling to the Netherlands. The goods are made in China and shipped direct from China to client, but my company raises the higher than you trading. Okay, so you are, Irene, you're kind of doing what we call cross-trade. So your goods are being shipped from China to the Netherlands, but they're never actually coming into the EU, into the UK, sorry. So in that respect, you there's technically 2 sets of documentation that's raised. It's really talking to DPD or FedEx, if that's what you're talking about, to understand how they do that. But what that means is that there's actually no bilateral trade agreement between China and the EU, so duties will apply anyway. But it does mean, for expediency's perspective, that can still continue. It's just there might be more documentation that's required. So it's really a conversation with either the FPO or the freight forwarder, whoever you're using. But if you talk to them about explaining cross-trade, that's technically what you're doing, where you've got like a triangular arrangement. The goods are never coming into the UK where you reside. You're raising the commercial invoice, but then the goods are been sent from source to customer, if you like. So I would ask them to explain what their requirements are around documentation for that, but talk to them about cross-trade, because that's technically what you're doing. Sorry, I'm conscious I'm waffling on here, so I'll go into the chat now, Sam. Yes, absolutely, slides from this week and last week. Yes, Sam, is that okay? Are you able to get those sent out?
Yes, yeah, that's no problem at all. We've got an email ready to go, and the recording and the slides will all be sent out within the next couple of days.
Okay, that's wonderful. Just scrolling down, so documentation, will we need a certificate of origin for every delivery? Which codes need certificates? We've been advised by Customs and Excise that unless we're requesting preferential duty, we'll not need a certificate of origin. Yeah, so there's 2 different types of origin certificate. There's those certificates of origin whereby they're not used for preferential trade, but they could be mandated by a certain country. So the Arab League of Nations are known to require certificates of origin for all imports going into their country or into their countries. It's really, the commodity code will tell you whether it's stipulated, and obviously when you're claiming preference and it's a preference certificate rather than a certificate of origin, then that's required to claim preference. But in terms of a standard or normal certificate of origin, it's really down to the individual country and sometimes the importer that may request it. for political or you know, trade statistic reasons or anything like that. So it's really a case by case. If you think about preference certificate, so what we've historically known as EUR1s or ATR forms, although they've ceased to apply and be replaced by a new UK one by the chambers, they're only issued where there is a preferential agreement in place. But those normal certificates of origin can be mandated in any case. You know, it's really down to having that conversation with your customer moving forward about, okay, what's the documentation that's needed to clear my goods at your local customs authority? And they'll be able to tell you quite quickly that, you know, you need a certificate of origin, or actually they themselves as the importer want the certificate of origin. So it's having those conversations with your customers really. But if you want to trade under preference, you absolutely need that movement certificate. And the new movement certificates that come in to replace the EUR1s and ATR forms will only be issued where the UK has a preferential trade agreement. And at the minute, as we looked at the trading landscape, that's limited at the moment. So we won't be issuing a huge amount of those for the foreseeable future. How can we obtain proof of origin if suppliers are reluctant and refuse to give info? We sell screws to France, imported from China. Will we need to pay for a certificate of origin every time we ship and for each? That's an interesting one. So will you need a certificate of origin every time you ship? There are a couple of things around here. So origin certificates can be replaced by exporter declarations. So you can make a declaration as to the origin of the goods, although that's usually the origin of your own manufactured goods. Trying to think about a way around that. In terms of actually having to provide a certificate of origin, again, that will depend on the country of destination, whether or not they require it. So if France is saying that they require a certificate of origin every time, then I can appreciate that's painful. However, for screws from China, I'm not entirely sure that they would. So I think it's looking at the commodity code and determining exactly what's needed to clear those goods it imports. Karen, if I haven't answered that question correctly, by all means, just drop me a line and I'll put some further thought into it. Gabrielle, we import capital equipment from Italy and export to the Republic of Ireland without modifying the goods. We'll be subject to customs duties one way, two ways, or not at all. Really depends. If you can, the way of suspending duty entirely in the UK would be to bring those goods into a bonded warehouse or a customs warehouse. Now that has a cost attached to it, but it might be less than actually paying the import duty. That means that once the goods come into that customs warehouse, they're never released into free circulation in the UK, which means that so long as they're re-exported to Ireland, as you say, then that import duty and import VAT won't be payable in the UK. And yeah, so that's bonded warehousing or customs warehousing would allow you to do that. We import some goods from Germany and Poland, customize, modify them, and then export them back out to Ireland. The goods come in CE marked, but if we export back out, yeah. So first point on that, if you're bringing goods in from Germany and Poland, you probably could use simplified procedures around inward processing, which would allow you to suspend the import duty and VAT on those goods coming in from Germany and Poland while they're processed or manufactured, and then re-exported back out to Ireland. Well, I never realised just how much trade we do with Ireland until Brexit happened. The goods come in CE marked, but so simplified procedures would be the first thing to look at if you're not already using it for inward processing. The goods come in CE marked, but if we export back out, do we need to mark with CE and the new UK CA mark? So as we discussed earlier, the UK CA mark will be a requirement for the UK market, but the CE mark will be a requirement for Ireland. So it depends. If those goods that you're manufacturing are never released into the UK, you could just obtain the CE mark. However, if those goods both go into free circulation in the UK and go into Ireland and perhaps other EU countries, then the product's going to have to carry both marks. But the absolute best advice I would give you on this would be to consult the BSI Like I say, they've got a foot in both camps. They can advise on both marks when and where they're needed and what the hurdles are you need to jump through to get them. So I hope that's kind of clarified that. If there are any other questions or things that I haven't covered, by all means, just drop me an email. I'm quite happy to have a think about them and get back to you. But I think that's it, Sam, in terms of Q&A and chat.
Excellent. Thank you very much, Andrea. Another really detailed session, and I'm sure a lot of information for everybody to take in. I would normally put our last slide up just with all of our Growth Hub contact details, but we are really, really tight for time today. I've got to on to starting another webinar. So I'm not going to do that today, but the slides will all be sent out to you all. Andrea's slides, our slides, all the contact details, and the recording of the session. So as long as you registered on Eventbrite, which you all will have done, you will receive the link to those bits of information within the next couple of days. We just top and tail the recording and then it's ready to go. So thank you again ever so much, Andrea.
You're welcome.
I look forward to seeing you again next week, and hopefully some of the same attendees as well. I'm seeing some names coming up week after week, which is great to see. So thank you.
That's perfect. All right, thanks ever so much, everybody. It's been a pleasure. Thank you. Bye.